Assalamu alaikum and welcome to all of you to another session of Practice to Pass F4 English Law. I'm your presenter, Ms. Shazia Malik, and yesterday we talked about certain areas of English legal system and contract law under the subject F4 English Law, and today we are going to resume from where we stopped yesterday. You can ask questions whenever you feel like, and all the handouts are provided in the handout section. So as I told you yesterday, well, the questions would be in MCQ format. 70% of your paper would be of multiple choice questions. 30% would be MTQs, multiple task questions. And those are scenario based questions, and we will be discussing those questions in a day or two in the coming days. So before attempting the question, you should have all the technical knowledge related to those areas. As we talked about terms yesterday, exclusion clauses, acceptance, privity, promissory estoppel, hierarchy of the courts. So you should know all these things before you try and attempt any question related to those areas. So I hope the voice is clear. I hope everyone can hear me properly. So let's just begin with breach of contract. Breach of contract and remedies. Yesterday, we formed a contract and we formed a contract by three elements: offer and acceptance, consideration, and intention. And then we saw certain rules regarding the terms of the contract, which would be a valid term, which would be an invalid term, what are exclusion clauses. So we talked about all those stuff which is needed to form a contract. So today we're going to see that how does a contract comes to an end. How does a contract comes to an end? So the topic today is discharge of contracts, beginning today with the topic of discharge of contract. The slides are also available and I will be explaining it on the notepad as well. So there are certain ways under which a contract can be brought to an end. Contract can be terminated. For example, one of the way is through performance. A contract can come to an end through performance. Performance is when all the obligations where one party has one obligation and the other party is another obligation, and when both the obligations are fulfilled by both the parties, of course, after the obligations are fulfilled, we say that the contract has been performed. Contract has come to an end through performance. For example, party A had to transfer goods and party B has to transfer money. So party A transferred good and party B transferred money. The contract, this is a successful contract. It has come to an end through performance. Moreover, a contract can be brought to an end through frustration as well. Frustration is like party A decided to pass his or her consideration, party B decided to pass the consideration. However, they could not do it because of some external uncontrollable factor, a factor which is not under their control, uncontrollable factor. For example, the contract was done with party B and party B's death occurs. So this is a factor which is going to make the contract uh, impossible to be performed. So out of frustration, the contract would be terminated. Contract would be brought to an end. Well, another factor is breach of contract, which is one of the most important factor. Breach of contract. Breach. Breach of contract. Well, breach of contract. Breach is a fancy way to say break, when one party breaks a contract. And regarding the obligations, when it comes to obligations, when one party completely fails, completely fails to comply with the obligations, either completely, either completely the party fails to comply with the obligation, or either completely, I've written completely, or they have performed the obligation, but it was not satisfactory. It was not up to the mark. So, breach is when one party fails to comply with the obligations either completely or satisfactorily. So, it is said that the party is at breach. So, breach has different categories. One of the fundamental breach is known as uh, repudiatory breach. You can see it over here. Repudiation occurs where a party indicates by word or conduct that they do not intend to honor their contractual obligation. So breach has different types, different types, and well, one of the category could be repudiatory breach. Repudiatory breach, where a party indicates that it has no intention to fulfill the obligation. Where a party indicates it has no intention to fulfill their particular obligation. That is what they say. They have no intention to fulfill their obligation. Then it has certain categories, like one of the breach is known as actual breach. Actual breach. Actual breach is that breach when the party announces on the due date, of performance. When the due date has come, the party announces that, well, they have no intention to fulfill their obligation. On the due date of performance, the party announces that the date is here, but we are not going to fulfill the obligation. That is actual breach. And another category is anticipatory breach. Anticipatory breach. Anticipatory breach occurs when a party announces that they have no intention to fulfill their obligation, when a party indicates that they have no intention to fulfill their obligation before the due date. Before the due date. So does the law give the innocent party any right to take action? Yes. As soon as the party indicates the anticipatory breach, the innocent party can bring up a case against that party, bring up a claim against that party of anticipatory breach, even if it is before the due date, because that is what anticipatory breach is. It is always before the due date. So breach has certain categories, and you should know about all these categories, certain types of the breach. Okay, let me see some questions. Yes, the recordings would be available for all the days, and you will be provided with the recording, and handouts are available on the handout section. So this is what breach is. The main way through which a contract can be described, which is related to our syllabus, is actually breach, and breach has certain types which I mentioned over here. And what happens when a breach occurs? What actually happens when a breach occurs? Well, when a breach occurs, well, damages has to be paid. Damages. So when one party does not fulfill its obligation, that party has to pay the remedy, the damages to the innocent party. Which party? Well, the party which did not fulfill its obligation. This party has to pay the damages to the innocent party. They would be paying the damages to the innocent party. So what those damages are actually? Well, those damages are financial compensation. You have to pay money. Those are financial compensations which are paid to the parties. And damages, basically, the purpose of damages is to put the innocent party in a position they would have been if the contract had been successful. What's the purpose of the damages? To put the innocent party in a position they would have been had the contract been successful. Had the contract been successful. So that is the main purpose of the damages. They put the innocent party in the position they would have been had the contract been successful. At times, certain remedies, this is also known as expectation interest. This is also known as expectation interest, where you put the party in a position they expected to be after the successful completion of the contract. At times, reliance interest is also sought by the claimant party, reliance interest. Now, what is a reliance interest? They put the innocent party in in a position they would have been had they not relied on the contract. Had they not relied on the contract, they put the innocent party in a position they would have been had they not relied on the contract. So basically, they put the party in a pre-contract condition. So damages are basically paid as a financial compensation to the innocent party. That is what the main aim of the damages are. Repudiated breaches and damages. Damages, you can see the definition from here as well. We'll talk about equitable remedies in a while. So expectation interest, reliance interest. You can see it on the slide in front of you guys. Okay, so another area in damages is, well, we talk about two definitions over here. Well, one of them is liquidated damage, and one of them is penalty clause. penalty clause. Now, what are these? What are liquidated damages and penalty clause? Well, when two parties enter into a contract, liquidated damages are decided by both the parties. Amount of the damages to be paid if one party breaches the contract. So, what is liquidated damage? Liquidated damage is it is basically decided by both the parties, and it is actually the amount of damage, how much damage would be paid, amount of damage to be paid when, to be paid when, to be paid if the breach occurs, if one party breaches, if one party is going to breach the contract, one party breaches the contract. And the most important thing is that, that these damages, this amount is actually a genuine estimate of the loss. So the amount of loss occurred would be almost equal to this amount. It is a genuine estimate of the loss. So if the breach occurs, the innocent party can go and claim liquidated damage from the court, at the court, from the offender party, and these losses are actually genuine estimate of the loss. So are they granted? Will these losses will be granted by the court? Yes, yes. Court will grant this. Court will grant. The court will ask the other party to pay this amount as it was decided in the case. Well, penalty clause. Penalty clause. In penalty clause, again, both the parties decide the amount, to be paid if breach occurs. If breach occurs, it is decided by them. It might not be written in the contract, but it is decided by them. However, the amount that they decide is way more than the loss suffered by the other party. It is not a genuine estimate. It is way more than the loss suffered by the innocent party. So when innocent party is going to go and claim the penalty clause, well, the court basically pronounce it as unenforceable. Unenforceable, as it is not the actual amount, the genuine estimate. Court says that, well, it is difficult for us to enforce that. Well, it is unenforceable. Why? Because it is not the genuine estimate. The amount is way, way more than the loss suffered. So court would decide on some amount, and that amount would be paid instead of this amount, because this is penalty. This was just there to deter the other party not to breach, just to deter the other party, just to bring them in the fear that they would be paying this much amount. So this is just to deter the other party not to breach. And this could be mentioned in the contract beforehand. This could not be mentioned in the contract beforehand. Moreover, at times there are some damages which court termed as unliquidated damages. Well, this is when the amount is not mentioned, and then it is at the court discretion. The court decides that what amount should be paid. That is unliquidated damages. So regarding damages, you should know this stuff. You should know what expectation interest is, what reliance interest is. And you should know what damages are when it comes to liquidated damage and penalty clause. What damages are when it comes to liquidated damage and penalty clause. Okay, moving on. Moving on. What else do we have? So before we move to some questions, let's just get some understanding of some more areas. Well, so when the damages are paid, there are two factors to be considered. Broadly, there are two factors to be considered. One of them is remoteness of damage, and one of them is measure of damage. Remoteness, that is the damage payable, and if it is, then how much is it payable, and measure means if it is, then how much, what should be paid. So remoteness of damage and measure of damage. Okay, so remoteness of damage, the concept of, you must have studied this before. Remoteness of damage, well, it talks about certain damages and which the innocent party would claim at the time of breach, and are they payable or no? Will they receive those damages or no? Well, they can broadly be divided, the damages can be divided. Some of the damages are natural consequence of the breach, and some of the damages are not natural consequence of the breach. So when a damage is a natural consequence of the breach, there are two categories, direct and indirect. Some of the damages are direct natural consequences of the breach, and some of the damages are indirect natural consequences of the breach. So when one party breaches a contract, natural, they should expect a natural consequence of the breach, and the direct natural consequence of the breach is granted straight away. Court would ask the defendant to pay the direct amount that is equal to the direct natural consequence of the breach straight away, because they knew if they're going to breach it, this is going to happen. Well, there are certain things which they knew could happen, but there were not that much chances of them to happen. So those are indirect natural consequences of breach. So are they granted straight away? No, they're not granted straight away. So how is the decision done? Well, the decision is done on the basis of balance of probabilities. State, not state, court. Court would see if there are more than 50% chances that indirect damage is due to the direct damage, then the damage is granted, and if the odds are less, if the chances are less, then this damage is not granted. It is based on probabilities. However, more important is this: when a breach occurs and something happens that not normally happens in such kind of breaches, so will that thing be granted? Well, that depends. Depends on what? Depends on that, does the defendant has prior knowledge that their breach can also bring this loss, this consequence? So if you have told the defendant has the prior knowledge that due to their breach, this could also happen, then they'll have to pay that. Damage. If the defendant does not know that if they're going to breach it, this is going to happen, and this is not directly related to the breach or natural consequence of the breach, this is an unnatural consequence of the breach, but if it happens, you'll have to pay for it. If the defendant knows, then they'll have to pay. Only in that case, court would uphold the claim of the claimant and ask the defendant to pay that amount to the claimant. So these are the issues regarding remoteness. what is the damage, and when that damage is payable. Remoteness of damage. And the next thing is measure of damages. What are the different remedies that are available? Measure of damages are the remedies that are available. Well, one of the remedy is known as action for price. Action for price, where the claimant sues the defendant and the party which has breached the contract and asked for the price of that and asked the amount that would restore the innocent party to a position had the contract been successful. So that amount is asked and granted by the court on the basis of balance of probabilities. Then quantum merit, another approach, quantum merit. Quantum merit is basically uh, is known as how much is it worth. It is basically granted for the work that has been performed already. The party asks for the amount for the work that has been performed already, and the party basically does not emphasize on the completion of the contract. They say that, well, we just want want the amount for the work that has been performed already, and basically it is used in construction contract. For example, if there's a house and it is 20% complete and they have some arguments, so the party would say, okay, we want the money for 20%, the work that has been performed, 20%, and that is known as quantum merit. That is called quantum merit. And then we have certain equitable remedies. Remember, we studied equity yesterday. So equitable remedy, the ones we have studied so far are common law remedies, but there are certain equitable remedies also introduced. One of the equitable remedy was specific performance. Specific performance, where the court, what is specific performance? Where the court asks a party to do something. Where the court asks a party to do something, to perform something. And it is basically a positive covenant. Positive covenant, where a court is going to ask a party to do something. And like this, another remedy is injunction. Injunction. Injunction is where the court asks a party not to do something or stops the party from doing that. Asks a party not to do something, or basically stops the party from doing something. It's a negative covenant, as you can see. It's a negative restriction, negative covenant that has to be followed by the party who has breached the contract. And another category is rescission. Another category, let me see where we are in this slide. We'll be talking about these questions in a while, and yeah. So the last category would be rescission. Rescission. So what is rescission? Rescission is, well, where this is basically not a breach, where both of the parties agree to end the contract just between the contract. So then the court is going to ask both the parties to pay the amount of money The court is going to ask both the party to pay the amount of money which could bring them into pre-contract condition. Pre-contract condition, where we have read that before, in reliance and trust. So rescission is reliance and trust. Pre-contract condition. Court is going to ask both the parties to pay such amount so that both of them can be brought to their pre-contract condition. So these are certain types of common law remedies and issues that the examiner would be most interested in when it comes to breach of the contract. You must have studied all of them before as well. So let's have a look at some questions. Okay. So, to what extent are damages awarded for a breach of contract? You need, let's see if you can answer these questions. Think of an answer in your mind and let's see if it's the same that I'm going to tell you. A, to put the innocent party in the position he would have been in if the contract had been performed. Excuse me. B, to restore the position of the innocent party to what it would have been in if the contract had never been made. C, to put the innocent party in the position he would have been in had the contract been performed, plus an amount of compensation, to restore the position of the innocent party to what it would have been in if the contract had never been made, plus an amount of compensation. So the answer is A. A is the answer. Another question. What does the claimant's duty to mitigate his losses mean? Well, these are the losses that are granted by the court. However, court always and always emphasizes and asks the claimant to make it a point that they should mitigate their loss. They should come to us when their loss is minimum. Try and mitigate, reduce their losses, reduce the amount that court would get them from the defendant. The claimant must take reasonable steps to ensure that his damages are kept to a minimum. The claimant must produce an itemized list of damages with supporting evidence, otherwise he will not be able to recover losses. The claimant cannot claim for losses that occur after the court hearing, so he would not expect to compensate it for the future losses. Well, the claimant must deduct the cost of his legal expense from his claim for the damages, as each party must pay his own legal bills in a civil claim. Well, as you see, the answer is A. A is the answer. So this is slide number 6 and 2 questions from here. Let's move on. The liquidated damage, we have talked about it. Genuine pre-estimate of the loss, action for price, quantum merit, we have talked about it. So which of the following is an example of equitable remedy rather than common law? Injunction, action for price, quantum merit. That is simple. Injunction. Rescission is an equitable remedy and where available makes the contract voidable. There are a number of conditions attached to the award of rescission. Which of the following is a condition that must be met for an award for rescission to be made? The innocent party only must be able to restore to their pre-contract condition. Well, no, both the parties. B, the right to resign the contract must be exercised within 30 days of it being awarded. Well, rescission should be done early in a contract, but 30 days is not a limit. Yes, doing that early is a point, but 30 days is not the limit. Rescission must take place after the contract is affirmed. Well, if you have confirmed the contract, that means you're going to carry it out. You're not going to resign it. Innocent third parties must not have acquired rights under the subject matter of the contract. Well, that is the answer. That is the answer. Okay. So, some more questions. In relation to the law of contract, which of the following statements in relation to damages is correct? Damages are not payable in relation to mental distress. Well, damages are paid. Damages to rectify a defect are still payable even if they are wholly disproportionate to the size of the breach. Well, I told you that the losses should be a genuine estimate. This says the damages are disproportionate. This is incorrect. An innocent party is required to take reasonable steps to mitigate their losses, and damages in the form of penalty clause are valid and enforceable. No, penalty clause are unenforceable. The answer is C. Next question. Which of the following statements in relation to liquidated damage is correct? Liquidated damage clauses are void and unenforceable in contract law. Well, they are not. Liquidated damages clause must be highlighted in the contract. The purpose of liquidated damage clause is to deter potential breach of the contract. This is the purpose of penalty, to deter. Liquidated damages are only payable where a condition of a contract is breached. Well, D seems an appropriate answer. D. So this was all about breach of contract. This is all about breach of contract. Okay. Well, let's have a discussion about the next area, and that is law of tort. So, what is law of tort? Tort is a civil wrong. It is a civil wrong, and of course, if a party commits the tort, the other parties can go for the compensation from the civil wrong, and all you can get from the case of a claim of a tort is money, compensation, as compensation is the only remedy for civil wrong. You cannot ask for imprisonment. And basically, being a citizen of a place, you have certain rights. And if everybody should honor your rights, that you are also a citizen of this place. But if somebody tries to uh, break those rules, or somebody tries to infringe your rights, infringe your rights and take those rights away from you, well, you can definitely place a case against them under the law of tort. Law of tort is different from contract. You can place a case against law of contract as well, but you can place a case against law of tort as well. It is different from contract. How? There are two major differences. Well, basically, the party can be a complete stranger. Stranger. In a contract, you cannot put a claim against a party which is a stranger. You have to satisfy all the elements. Well, here the party is a complete stranger, and all you can get is a small amount as compensation, no other remedy. Compensation, no other particular remedy, like remedy of specific performance, remedy of injunction, no equitable remedy, just the compensation. The party could be a complete stranger. complete stranger. So as you can see, no previous relationship need to be exist between the parties. No previous relationship should be there. One of the biggest example of tort is negligence. Negligence is when you carry out your work in a careless fashion, in a careless manner. You do not show the amount of care that is expected out of you. So the main example over here is negligence. Negligence. When whatever you do, whatever work you carry out, you do that carelessly. You do not show the amount of care that is expected out of you. That is negligence. That is negligence. And whenever a claimant, a person goes to the court and takes up the case of tort of negligence to the court against this defendant, well, court asks to claimant to provide the proof for three things. The claimant has to prove three things over here, and those three things are: number one, claimant has to prove that their duty of care existed. The defendant had a duty of care towards the claimant. Claimant has to prove that. Number two, the claimant has to prove that duty of care which existed has been breached. Defendant has breached that duty of care, and the claimant also has to prove that the claimant has suffered loss at the expense of that breach. Until and unless these three things are proved, you're not going to get any amount from the defendant. So first thing you have to prove is that duty of care existed. So whoever person you come into contact with and the person says that you have infringed their rights and you have not shown enough care towards us, towards that person, so certain factors would be considered over here, and the neighbor principle, neighbor principle will be applied. That is the person in that much close proximity with you for the tort to be liable, for the tort to be liable, for you to be liable for the tort. So you have to consider the proximity, the level of proximity. Are you related, and is there any fairness in this concept, and does the person has duty of care towards you or no? So neighbor test would be applied over there. And duty of care when a professional is involved, we are going to talk about it in a while. When a professional is involved, so duty of care of a professional is way high, way more than a layman, a normal individual. Why? Because a professional is in an expert capacity. A professional is in an expert capacity, and the other person is in a normal capacity. So whenever there is a dealing between a professional who is in an expert capacity with a person who is in a normal capacity, a normal individual, a layman, so special relationships come up. Special relationship. The relationship is termed as special relationship. So for special relationship, a higher degree of care should be shown. Higher degree of care should be shown whenever there is a professional involved. We'll talk more about it in a while. And the next thing that the claimant has to prove is that duty of care has been, DOC is the short form for duty of care, I write it that way. Duty of care has been breached. Has been breached. There are certain factors over here which comes into consideration. We'll talk about these questions in a while. Well, dependent has to owe the duty of care, so you have to see that the harm was reasonably foreseeable, the proximity was there, and it is fair and just. If these three conditions are satisfied, yes, the duty of care does exist. So then for the breach of duty of care, some of these are the factors which are considered. Probability of injury. So whenever you need to know that whenever you're dealing with people of certain age, who are old, who are young, or who are not able, disabled, you need to show some extra care. People with of certain age, who are old, who are young, or who are disabled, you need to show extra duty of care towards them. So the factor that we can consider over here, factor that can be considered while seeing that duty of care has been breached or no, could be these: probability of injury. Whenever the probability of injury is more, you need to show some extra care. Regular care would not be enough. You need to show some extra care. As I just told you, with people who are of certain age or who are young or who are disabled, certain old age or young or disabled, so you need to show extra care towards them. Or when you see that seriousness of the risk is more, if it is going to occur, it is going to bring serious consequences, then you need to show extra care. However, if it is your common practice and you do that normally, and the claimant, you have conveyed this to the claimant that this is our common practice and we just show this level of care, this level of duty of care, then that is okay. You do not have to show some extra care. Moreover, even if you're working for some social cause, it is allowed not to show some extra care. For example, it is a fire brigade and fire brigade is over speeding. That is not normally allowed. However, it is allowed to the fire brigade because it is working for some social benefit, for some social cause. And moreover, if the defendant says that practicality and cost has been considered and what was practically possible, what money we could spend on this to show our care, we have spent it, and to spend more it is not possible practically, then again the court says that yes, okay, the duty of care has not been breached, it has been satisfied. So these three factors you can see goes in the favor of the defendant. And finally, professional duty. When a professional is involved, professional duty of care is way more than a normal. Why? Because there is a special relationship between professionals and laymen. These are the certain factors. You must have studied them. So let's see. So we started from here. Yeah. So let's have a look at some questions. What is the standard of care applied to professionals with a special skill or expertise? That of the reasonable person with the same skill or expertise, that of the reasonable person in the same general profession, that of a reasonable person, that of the reasonable person with the same level of experience in that skill or expertise. Well, The most appropriate answer is D. D is the most appropriate answer. What does the egg shell skull rule mean? Well, it is the same rule as I just told you. You have to show some extra care towards old people, young people, and disabled. So this rule basically, the definition of this rule is part B. The defendant must take their victims as they find them. Defendants must take their victims as they find them. If they find them old, young, or disabled, they must show extra care. The answer is B. Egg, shell, skull rule mean defendant must take their victims as they find them. So, when do acts of nature break the chain of causation? Well, we have not studied that. And, well, let's do a little more discussion before we do move on to the next questions. So these are the areas for duty of care and the rules. And the third thing that the defendant has to prove is that the defendant has suffered loss. Well, before going to that thing, I would like to mention over here that it is also mentioned in tort that pure economic loss, if it is a pure economic loss, it is not recoverable under tort. Pure economic loss. What is pure economic loss? Well, which is not related to, which did not occur due to some physical injury, or damage to property. So, if a loss which is not related to any physical injury or damage to property, it is termed as pure economic loss. And is it recoverable at the court of law? Well, the answer is no, it is not recoverable. We are not going to recover any pure economic loss, that loss which is not related to physical injury or damages to property. It is not recoverable under tort. However, if it is related to any physical injury or damage to property, then it is known as consequential economic loss. Consequential economic loss. So consequential economic loss is recoverable. This loss is recoverable and pure economic loss is not recoverable. So if a question comes up, so are pure economic losses recoverable under tort? The answer is no. And the question is going to come up. It is repeated mostly, this sort of question. So the third thing that the claimant has to prove is that the claimant has suffered loss because of the defendant's action. And there are certain points over here. For example, point number 1 is but for test. Claimant has to prove that has it not been but for the action of the defendant, the claimant would not have suffered the loss. So the claimant says, if the defendant would not have performed this action, I would not have suffered this loss. And the claimant proves that. So court says, well, okay, if this is the case, yes, you're going to get the compensation. The claimant proves that if it was not for the action of the defendant, I would not have suffered the loss. If the claimant proves that, court grants the compensation. At times there are multiple causes because of which the loss has occurred. So for multiple causes, the court have a look at it case by case. At times, all of the people responsible for the causes responsible for the damage, they are penalized, and at times some of them are penalized. So case by case it is decided. And the third is chain of causation. Chain of causation, which is known as, the phrase is used novus actus intervenient. That is the phrase that is used over here, novus actus intervenient. So if there is a chain and the claimant says, well, there is a chain and this is uninterrupted, and the chain says that loss is due to the defendant, the court will ask the defendant to pay the compensation. However, chain of causation can, at times, this chain of causation is broken. So there comes some other reasons as well. So when those other reasons come, so basically it is said that the chain is broken now. The losses are not entirely because of the defendant. Defendant would pay some amount, but the rest would be shared by these causes. The causes of these, that why the chain has been broken. So the first factor, the chain can basically be interrupted by claimant's action. Claimant action. Defendant has showed negligence, however, the claimant was negligent as well. The claim can be distorted by third parties' action as well. The third party's action. Negligence was on the part of the defendant as well as the third party. But remember, the third party negligence should come after the verdict of the defendant's case. The third party negligence comes later. So when the losses has been increased, but court says that increased loss is due to the third party, it is not due to you. And at times it is broken by natural events as well, but those natural events which are unforeseeable. If you can see if you can foresee a natural event, well, then that loss would be bared by the defendant. But if you cannot see, it is unforeseeable, it was a natural, it happened as it is, so then the court says, well, it is not fair to allocate all those losses to the defendant. This is the chain of causation. So you need to know all these things, all these methods when solving the third element, and that is suffered loss. One of the tests is but-for test, one of the tests is multiple causes test, and one of the tests chain of causation. Chain, what can break the chain? Claimant's action, third party's action, and those natural events which are unforeseeable. And pure economic losses, they are never recovered under tort. So whenever a party is basically accused of tort, well, what does that party can say in its defense? Can the party say something in its defense? Well, yes. There are two defenses that are available for the law of tort. So let's see if we can solve the questions. When do acts of nature break the chain of causation? Always. They always do this. Where they are unforeseeable but linked to the original negligent act or omission. Where they are unforeseeable and separate from the original negligent act of omission. So the answer is C. In which of the following situations will a defendant be liable for his negligence? The defendant would be liable for his negligence if the loss would have occurred regardless of the defendant's negligence. If but for his negligence, the loss or damage would not have occurred. If there is novus actus intervenient. The answer is B. If but for his negligence, the loss or damage would not have occurred. So had there been no negligence on the defendant part, the damage would not have occurred. The answer is B. Defenses to negligence, contributory negligence, and voluntary non-fit injuria. Two defenses are available: contributory negligence and voluntary non-fit injuria. So contributory negligence means when the defendant proves that yes, he was negligent, but there was negligence on the claimant's part as well. Then court would reduce the amount of compensation. Court will reduce the amount of compensation from 10 to 75%. At times it could be 100% as well. And what is voluntary non-fit injuria defense? Well, this is the defense when the defendant proves to the court that we have mentioned all the risks to the claimant and the claimant has agreed to take up all the risks. So this is not our fault. At that, the court basically decreases the amount of compensation and to 100% as well. So where the claimant voluntarily accepted the risk that caused the loss or damage, then the defendant will not be liable. Acceptance can be expressed or implied. And contributory negligence, as I told you, reduction could be between 10 to 75, but it could be 100% as well. It could be 100% as well. So which of the following statements regarding tort is correct? Slide number 17. Which of the following statements regarding tort is correct? The only remedy for a victim of tort is damages. No contractual relationship need exist between claimant and defendant for the defendant to be liable for the claimant in tort. Action in tort are heard in the criminal court. No, they are heard in civil court. In tort, the burden of proof is always on the defendant to prove that they were not negligent. The burden of proof is on the claimant to prove that that defendant is negligent. The answer is B. No contractual relationship need exist. There is no need for the contractual relationship. So next question. Which of the following circumstances will prevent causality being established in a claim of damage? An act of claimant that is reasonable and within the normal course of things. What will break that chain of causality? Claimant's normal action? No, it will not break. Act of a third party that occur after the claimant's injury? Foreseeable natural? No, it should be unforeseeable natural. So A and C not the answer. Multiple possible reasons for the injury. No one act being established as the cause. So this is not the answer as well. So the act of a third party, well, we have read third party, but it occurred after the claimant's injury. So this is not the answer. In fact, this is the answer. Let's have a look at some other questions. In which of the following circumstances would an employer be vicariously liable for the acts of the employee? So what is vicarious liability? Well, vicarious liability says that, okay, before doing these questions, let's have some more discussion. So we have talked about the defenses as well. So what is left? Yeah. So regarding tort, so now we're going to move to professional negligence. Professional negligence. And vicarious liability is a term that is being used, that this term says, vicarious liability says that if an employee has committed an act of tort, his employer is liable to pay. Employer would take the liability if the employee was at his premises, if the employee was at the working hours, and if he committed tort, the employer has to be liable for the act of the tort of the employee. That is vicarious liability. And talking about professional negligence, and whenever there's an auditor, and whenever the auditor is performing just the audit rule, the auditor is liable to the existing company, or existing shareholders for their existing investment or existing shareholding. So the liability of an auditor is bit of limited when they're performing just the audit role. However, if they do something more than the audit role, if they do something other than the audit role, for example, they perform some consultancy, they provide some consultancy, so the liability is extended. Liability is extended if they perform any professional negligence performing non-audit role. The compensation that they would have to pay would be more. It would be more compensation that they would have to pay. So it is limited when the auditor is performing just the audit role, and it is extended. It is extended when an auditor performs a non-audit role. Moreover, regarding the auditors, if a subsidiary company's auditor acts negligently and gives a negligent report, so can the parent company sue for the action of tort? Well, yes, the parent company can sue. Why? Because the information from the subsidiary company are brought up to the parent's company account when they are making group accounts. However, if a parent's company auditor performs the work in a negligent fashion, does the subsidiary has any action of claim, any right of claim? Subsidiary company? Well, the answer is no. Subsidiary cannot sue the auditor of parent company because no specific information is channeled down to subsidiary's account. However, parent can sue subsidiary's auditor on the law of tort, on professional negligence, on performing their work in a negligent fashion. So, in which of the following circumstances would an employer be vicariously liable for the act of the employee? Where the loss or damage was caused by employee when performing the duties they were employed to do so. When the duties they were employed to do, where the loss or damage was caused by the employee but they were not on the company business at the time of the incident, where the employee has a valid defense to liability and the injured party has no other course of action available to them. So the most suitable answer, as you can see, is so you must have come up with an answer in your mind. The answer is A. The answer is A. What forms the basis of existence of a legal duty of care in negligence for misstatements resulting in economic loss to the claimant? Proximity, proximity and damage, forcibility, and forcibility and proximity. What forms the basis of the existence of legal duty of care in negligence for misstatements resulting in economic loss to the claimant? So there were misstatements and they have resulted in the economic losses to the claimant, but some sort of proximity and damage should be there if you want to go for the economic loss. As I told you, the physical damage and damage to the property should be there. B could be the answer. Next question. In the tort of negligence, what is the effect of voluntary non-fit injuria? The defendant is liable for the claimant's injury unless proved otherwise. The claimant accepted the risk of injury and the defendant is not liable for the losses. Neither the claimant nor the defendant is responsible for claimant's injury. So think of an answer in your mind. The answer is B. B. To establish a case of passing off. Now, what is passing off? Passing off is a tort. It is going to come again as well in company law when a company uses the name, brand name of another company and misleads the customer. So the consumer purchased fake goods A. The defendant is using a similar business model to the claimant. The name of the defendant's business is similar enough to the claimant to mislead the consumer. There is some similarity between the name of the defendant's business and that of the claimant. So two factors should be there. There should be similarity in the name as well as in the business. Plus it should amount to something that could mislead the consumer. So then the tort of passing off can be actionable. The answer is C. The answer is C. So this is what the law of tort is all about. So time for a break and we will resume at it is 11. We'll resume at 11:25. Okay, welcome back, people. So we have talked about breach of contract and we have talked about law of tort and professional negligence so far. So the next topic is employment law. So that is another area for F4. And before we do move on to practice, let's just do revision of some key technical topics under employment law. So the very first distinction that you need to do under employment law is basically you should know how to differentiate between an employee and the self-employed. How can we differentiate between employee and a self-employed? Independent contractor, self-employed, independent contractor. So let's just write independent contractor as well. So there are certain factors which would help you to distinguish, to differentiate an employee from an independent contractor. So what are those factors? Well, one of the factors that you could consider is the control factor, or you can perform the control test. So if the work of the employee is controlled by the employer, then he is an employee. If the employer controls that how much work you would do, where are you going to perform the work, at what time, when are you going to perform it, then you are certainly an employee of that person. Controlled by the, sorry, I've written employee, controlled by the employer. But if your work is not controlled by the employer does not decide that where are you going to work, when are you going to work, how much are you going to work. If it is not controlled by the employer, well then you are definitely an independent contractor. That would be one of the deciding factor. Another test is integration test. Integration. So what does that mean? Integration means that if the work that you perform, if the work performed by the employee is an integral part of the business of the employer, is a main part of the business of the employer, and you are basically hired to do that work, then you are definitely an employee. It is the main part, it is not a subsidiary purpose and not just used as an accessory, it's an integral part. Then you are the employee of that person. And if the work that you perform is not an integral part, it is ad hoc, it comes at times that you need the work and you need the work to be performed, and it is not an integral part of the work carried out at the employer's premises, then you are a self-contractor, you are an independent contractor. So these are the factors that could be considered, and then there are certain factors which come under economic reality factors. Economic reality factors, and there are a number of factors over here. Number of factors. For example, as I just told you, control and integration. Control and integration. So when you consider overall economic reality test. So when the employer can control your work and you are doing an integral part, then you are an employee. Otherwise, you're a self-employed. If they cannot control, then you're a self-employed. Okay. Provision of tools. Provision of tools. If the employer provides the tools for you to carry out the work, if the tools are provided by the employer, then you are an employee, you can see. And if the tools are not provided by the employer, you bring your own tools, well, then you are an independent contractor. Provision of tool could be another factor as well. And can you have your own helper? Can you have anybody to help you out? So if you can have your own helper, then you are an independent contractor. But if you are not allowed to have your own helper, then you are not an independent contractor, you're an employee. You will be performing work yourself. You are not allowed to have a helper or send a substitute. And when there are regular methods of payments, payment is on a regular method. Yes, there's a regular method always for payment. You're an employee. Well, no, there's no one regular method of payment. When there are regular hours of work, regular hours that you're going to work, yes, there are regular pet hours, for example, 9 to 5, 9 to 6. No, there are no regular hours. They keep on changing. These are the factors which sums up. When they all sums up, so they decides whether a person is an independent contractor or whether a person is an employee. So reality of the situation should be taken into account. With an employee, a contract of service is carried out. With an employer, a contract for with an independent contractor, a contract for employment is signed. Employees normally gets net pay, but they can opt for gross pay as well. But independent contractor would always and always get a gross pay. So why is it important? We have done this distinction, but why? Why is it important to distinguish that whether a person is an employee or an independent contractor? But it is important for certain factors. Why? Well, these are some of the factors. Because employee pays class 1 national insurance contributions and deductions are under pay as you earn. For an independent contractor, it pays class 2 or 4 national insurance contribution and they're basically not awarded pay, they go and pay the tax themselves. Legal protection. Well, more protection are available for employee, lesser are available for independent contractors. Contractual rights. Rights and duties, which we are going to talk about in a while, well, they are owed to the employees, not to the independent contractor. VAT, well, the employee can use VAT of his employer, so it is irrelevant. However, an independent contractor may need to register for VAT himself. At the time of bankruptcy, employees are the preferential creditors as opposed to the independent creditors. Employees are preferential creditors. And for health and safety, well, more health and safety protection is provided to employee. It is provided to independent contractor as well, but more is provided to employee. So yes, this distinction is important. And you can have an employment contract. You can write all these things in an employment contract. Employment contract, which is basically signed by the employer and the independent contractor. And some of the terms could be express and some of the terms could be implied in that contract, and that contract basically clarifies that what is included, what is excluded, and all the obligations to be performed under the contract. We're going to talk about rights and duties in a while. So talk about this question: when is an employee entitled to written statement of prescribed particulars of the employment? Immediately on commencing the employment, within 1 month of commencing employment, within 2 months of commencing employment, or after completing the trial period? Well, after completing the trial period, after completing the probation period, the particulars are handed over to the employee. The courts can use a number of tests to determine if a person is employed or self-employed. So self-employed, another name for independent contractor, remember? So which of the following is not one of the tests used to determine employment status? Integration test, it is a test. Economic reality test, it is a test. Factual test, well, let's see. D, control test, it is a test. Which one is not? Factual test is no test. So these are the rights and duties that are provided by the statute. So under employment law, there are certain rights and duties levied upon the employee as well as the employer. And you should get that the well duty of one person is the right of another person, and right of one person is the duty of another person, employee, employer. So we are going to talk about duties of employee, which would be the rights of the employer, and duties of the employer. So we are going to have a look at them in detail. So talking about duties of employee and the duties of employer. So for employee, there are certain common law duties, and for employer, there are certain common law duties as well as statutory duties. Common law as well as statutory duties. So under the Employment Act, the employees are supposed to follow certain common law duties. Duty of a faithful service, duty of obedience. Obedience means following the lawful orders of the employer. Duty of due diligence and care. We have read care and law of tort before. We studied them. Due diligence and care. Duty of personal service. Well, you cannot have a helper or a substitute. You'll have to personally provide the service. Duty of competence. Whatever you do with professional competence. So these are certain common law duties that the employers would expect out of any employee. Employer would expect out of any employee. Likewise, there are certain common law duties for the employer as well, which the employees would expect. For example, pay remuneration, pay salary, pay remuneration. pay remuneration. For example, provide work. For example, indemnify the employee for the expenses that the employee has done on behalf of the organization. For example, health and safety. So these are certain common law duties which the employers owe to the employees. Employees expect out of the employer. Then there's certain laws, certain statutes that are forms, statutory acts which the employers have to follow. So duty of the employer, pay, health and safety, equality, justification. Equality, as there are certain acts like, for example, when it comes to pay, Equal Pay Act, which basically talks about no discrimination, or Minimum Wage Act. You should follow these acts. And health and safety, extended health and safety regulations. So there are statutes, there are certain laws on them as well. And time off work, when the employee demands time off work to carry out certain activities. For example, time off work for official strikes. For example, time off work for after redundancy, they need to go and find a new job. And most importantly, when you have a female employee and she decides to have family, bear children, and the would-be mother gets the maternity leave for antenatal care before the birth of the child. So time of work for maternity leave is very important. As you know, it's a lengthy time period. It's very important. 52 weeks extended maternity leave is paid, out of which 39 days paid leave and the rest of it is unpaid leave. So whenever maternity leave is granted, three rights are attached to it. Number one, right of leave. Number two, right of paid leave. And number three, right to come back to work. After this extended period, when the female employee returns to work, you cannot simply say that, sorry, we have hired somebody else. They have right to come back to work. So this slide, this page would basically summarize all the duties and rights of an individual. So you can see that time of work is an important area over here. So identify whether the following statements are true or false. An employer has an implied duty to behave reasonably and responsibly towards the employees. An employer has an implied duty to provide a reference. Well, that is also duty, provide a reference. So whenever the employee leaves your organization and goes to another company, that company, you must have studied in your BT, in your F1, that company might ask you for the reference, that how was this person as an employee. So you should be providing reference. That is also a duty. So providing a reference is a duty. Two only is the answer. Two only. So all these duties are towards the employee who is a continuous employee, and continuous employee is a person who has served you at least minimum for 12 months. And if your organization was taken over by another organization, if you worked for an organization for 10 months and another organization acquired your organization, your service is going to continue. Like after 2 more months, you will be a continuous employee. That is known as continuity of the service. So much of the statutory employment protection is only available to employees with 1 year's continuous service. So as I just said, transfer of undertaking. So when it is transferred, it does not break your years of service. It is basically continued. So let's see what more your examiner can ask in this area. Which of the following factors indicates that a person is self-employed rather than an employee? A person owns their own tools. The person is paid a salary net of tax. The person may not delegate their obligation to someone else. And the answer is A, as you can see. They provide their own tools, so they are self-employed. Which of the following is a test to determine a worker's status? Neighbor test, well, that was for taught, to develop, taught that proximity, under the concept of proximity, that duty of care is owed or no. Multiple economic test, reasonableness test, and test of remoteness. The answer is B, multiple economic reality test. So you should know the name of all these tests, and you should have all the technical knowledge regarding all these things. Another question, which of the following statements suggests that A is an independent contractor in relation to the work he carries out for B? He is required to provide his own tools. Yes, he is an independent contractor. He is required to carry out his work personally and is not free to send a substitute. No, this would go for an employee. 3, he is paid in full without any deduction of income tax. So 1 and 3 could give you a hint, 1 and 3. The answer is C, 1 and 3. So if the pay is deducted, income tax is deducted, the person is termed as employee, of course. Let's have a look at some more questions. Which of the following is a consequence of being self-employed rather than employed? In the event of employer's bankruptcy, the person has preferential rights as a creditor. No, employees have preferential rights. The person can register for and charge VAT. The person is entitled to remedies for unfair dismissal. Well, the only benefit is B. In fact, the only consequence is B. Unfair dismissal not granted to individual employees, self-employed. Which one of the following statements is correct? An employer is obliged to provide a careful and honest reference. An employer is obliged to provide a safe system of work. An employer is obliged to provide employee with smoking facilities during authorized breaks at work. An employer is obliged to give 2 days off a week. Well, D and C could not be correct. It's either A or B. An employer is obliged to provide a careful and honest reference. An employer is obliged to provide a safe system of work. Well, safe system, both of them are the answer, basically A and B. You have to provide a reference. And if you had to choose one, it would be B. Safety, health and safety at work. This is an obligation. Health and safety at work. Okay, moving on, some other technical aspects regarding employment law. So we have seen that how does a contract comes up, how can you make a person your employee. We have seen all that. Now let's just see that how does dismissal occur. How does dismissal occur? So whenever you're going to dismiss a person, the notice period is a must. A notice period should be given by a person who is leaving the organization, or if you're dismissing some individual. So notice period, there is statutory minimum to the notice period which the law has decided. So it should not be less than that minimum. It can be more, but it cannot be less than statutory minimum period. So if a person is employed, continuously employed for 1 month but less than 2 years, then 1 week notice is given. So what is that statutory minimum? Well, that statutory minimum is for 1 month is an employee, more than 1 month but less than 2 years. Less than 2 years. So how much notice should be given? 1 week notice. And if the person is employed for more than 2 years but less than 12 years, less than 12 years, 1 week per year employed. So less than 12 years, the notice period is 1 week per year of service. For example, if a person has been employed for 6 years, is a continuous employee, the notice is 1 week into 6 weeks notice. And if a person is employed for more than 12 years, well, 12 years notice is the statutory minimum. 12 years notice. Sorry, 12 weeks notice. More than 12 years, 12-week notice. So these are the statutory minimums. These are the statutory minimums. So, as it is said, notice must not be less than the statutory minimum. It may be given without specific reason unless the contract states otherwise. So you can give a notice until and unless it is not unfair wrongful dismissal. So, once we have decided on the notice, well, there are 4 ways through which an employer can dismiss uh, an employee. Number one, summary dismissal. Summary dismissal. Number two, constructive dismissal. Number three, wrongful dismissal. And number four, unfair dismissal. So you can follow the flow chart. 4 ways of dismissing an individual. Well, in these two conditions, breach of contract occurs. Breach of contract. Which contract? Employment contract. So two parties, employer, employer. So who breaches in summary dismissal? Employee. Employee breaches the contract and the employer dismisses the employee summarily. Summarily means by either reducing, summarizing their notice period, or even not giving a notice, not even giving a notice at all. So who dismisses in summary dismissal? Who breaches in summary dismissal? Well, The employer breaches in summary dismissal, and so employer ultimately dismisses. Well, who breaches in constructive dismissal? Who performs the breach of the contract? Employer. Employer breaches any term of the contract, so that employee can claim for constructive dismissal. So in both of these dismissals, breach of contract occurs. Summary dismissal, constructive dismissal, employer unable to continue. Both example dismissal without proper notice, and you can see that constructive dismissal occurs where the employer, although willing to continue the service, repudiates some essential term, repudiates the term. Wrongful dismissal. So this is about summary and constructive dismissal. They're going to come again in wrongful and unfair dismissal. Talking about wrongful dismissal. Common law concept arising specific circumstances giving an employee an action for breach of contract. For example, where insufficient notice has been given. For example, where insufficient notice has been given. So, wrongful dismissal is when you dismiss in a wrong way. Wrong way. When you dismiss in a wrong, inappropriate way. For example, the notice period that the employee deserves according to these statutory minimum was of 6 weeks, and you have just given 2 weeks notice period. So employee can go to the employment tribunal and ask for the compensation for this wrongful dismissal. However, employer might have some valid reason for doing so. Employer can give something as justifications to the court, and if the court is satisfied, the court would not grant the compensation for wrongful dismissal. What are those justifications that the employer can give? Employer can say that there has been willful disobedience of lawful order. Employer can say that employee has disobeyed me, willful disobedience of lawful order, or employee has performed some sort of misconduct, there has been some sort of dishonesty on his part, that is why I have reduced the notice period. There has been some sort of incompetence or neglect, because of that negligence I've done this. The negligence has been gross, it has occurred again and again, and the immorality has occurred. Well, immorality, the person or the employee is supposed to behave courteously at work. When you're at work, you have to show certain moral standard. You have to show certain level of courtesy, and if you're not doing that, and if it affects your performance or others' performance, so immorality could be one of the reason. Drunkenness could be one of the reason. Being drunk at work and it has aggravated and it has been repeated, is that the action has been gross despite all the warning. So if you're able to put any of this reason as justification, the employer can get the case in his favor. Otherwise, the employee would be granted compensation for the wrongful dismissal. So let us head towards a break. And the session would resume at 12:10. Okay, welcome back. So we were talking about dismissals. Okay, so the next category of dismissal is unfair dismissal. Unfair dismissal. Well, one of the major types of dismissal, statutory concept, and as you can see, as a rule, every employee has the right not to be unfairly dismissed. There should be a fair enough good reason for the dismissal. Distinction between basically the between unfair and wrongful is on the remedies, and the remedies for unfair are more. Remedies for unfair are generally in the form of compensation, and they're more. So, whenever you're going to go for unfair dismissal, so what is an unfair dismissal? When the employee thinks that they are not dismissed on fair grounds, and what is the criteria that tells that you qualify for unfair dismissal? Well, you have to prove that you have been continuous employed for 2 years, you have been dismissed, and you have been unfairly dismissed. You have been unfairly dismissed. So, continuous employment for 2 years, and you have to prove that you have been dismissed and you have been unfairly dismissed. You have to prove this thing to the tribunal. Tribunals are the smaller courts which hears the cases of employment. So for cases of employment, we refers to employment tribunal, and the appeals goes to employment appeal tribunal. So in tribunal, one there is representation from one party, and then there is representation from another party, and then the group of people or panel sitting there decides on the verdict. So if these three criteria, if you think that you can fulfill these criteria, you can go for the claim for unfair dismissal. And you need to you need to apply to the tribunal, and you have to show that you have been unfairly dismissed, and the employer basically shows that let me just write it down for you people. The following steps are followed. Well, you have to reach out for the employment tribunal within 3 months. 3 months will reach out to the employment tribunal, and employee would be given a chance to speak out, and employee has to prove that he or she has been dismissed unfairly. Employer would also be given a chance to speak out, to give the justification that what does he has to say in his or her defense. And there are certain type of justification which are basically accepted by the court. I'll talk about them in a while. And then they give their decision, they give their verdict. The tribunal gives the verdict. So these are the steps that you're going to follow. Which of the following is not valid for the dismissal of an employee? Dishonesty, it is. Willful disobedience of a lawful order, it is. Membership of a trade union, it is not. C is the answer. Where can a claim for wrongful dismissal be brought? Employment tribunal only, county court only, county court, high court, employment tribunal. Well, the answer is A, employment tribunal only. So, if the claims for unfair dismissal After the claim of the unfair dismissal, well, during the claim, the employer can provide certain justification, and that why does he think that he has dismissed the employee fairly? He has the fair reason to dismiss the employee. So, well, one of the fair reason could be the legal prohibition. For example, he's a practitioner and he has some of his act outside the work or premises has led him to the cancellation of his or her certificate or his or her license. So basically, you cannot call them back to work. Gross misconduct which was gross, which has to be gross misconduct could be a fair reason. So technically, in justification, you are saying that we have a fair reason to dismiss. We have a fair reason to dismiss. So legal prohibition could be a fair reason. Gross misconduct from the employee side could be a fair reason. Redundancy could be a fair reason as well. We'll talk about redundancy in a while. Redundancy is also a fair reason, or any other reason. The reason which you think is a fair reason. For example, if the person got married to somebody in the immediate competitive organization. So yes, that's a fair reason to dismiss the employee. And there could be some automatically unfair reason as well. Automatically unfair reason as well. For example, when a female returns from the maternity leave, as I just told you, right to come back to work is a right that is granted with maternity leave. So if the female comes back and you dismisses them, that's a complete straight away unfair reason. So the employer can get the case in his favor if he can provide some of the reasons where he says that, well, I have dismissed the person because of these reasons and these are fair reasons. Otherwise, the case is going to go in the favor of the employee. So if this claim for unfair dismissal is successful, what would be the remedy? What would be the remedies for that? What the employer has to pay? Well, employer can be asked to pay reinstatement. Reinstatement means giving the employee his or her job back. But if that place is occupied, you can give them some other place in their organization, and that would be termed as re-engagement. So reinstatement is one of the remedy, re-engagement is another remedy. Moreover, you can get compensatory reward as well. You can get money as compensation as well. So basic award, compensatory award, and punitive award. What is the basic award? If the person who is dismissed is 41 years or older than that, 1.5 weeks pay for each year of service will be paid. So basic award, the very first award is basic award. Person is 41 or above, he will get 1.5 weeks pay per year of service, maximum to 20 years. If the person age is between 22 and 40, he will get 1 week pay per year of service. And if it is below 22, the age of the person is below 22, they're going to get half a week's pay per year of service. That is basic reward, maximum to 20 years. 20 is the cap. That is basic reward. and then you can get some compensatory award for any additional loss of earnings, expenses, and benefits of, on common law principle of damages. You can get at any age. You can claim for some. The court can grant some compensatory award. Of course, monetary award in the form of monetary award, and additional award is granted as well at times. Additional punitive award is granted at times as well at the discretion of the court. A number is decided between 26 to 52 weeks, and the pay for those weeks would be paid 22 and between 26 and 52 at the court's discretion. Some number between these is decided, and it would be multiplied with 1 week of pay, and that would be granted. And that would be granted. Additional punitive award. So these are the remedies for unfair dismissal. Unfair dismissal is really important. And one of the fair reason for unfair dismissal was redundancy. As I told you, one of the fair reason for unfair dismissal was redundancy. When the employer says, well, I have not unfairly dismissed the person, I have made him redundant. So redundancy, when the employer has ceased or intend to cease carry on the business in which the employee has worked, or when the requirement for that business for employees to carry on the work has diminished. Either the employee is going to say that I have ceased the business, or the employer has to prove that, well, this particular person is no more required because the job that he or she performs, that particular work, or at a place where they perform. For example, if you have two branches and you're closing one of the branch, so you need to cut down on your staff. So you say, well, I'll make all my staff at this branch redundant. I don't need them anymore. So you have to prove this. And if you get redundancy payment, you have to have 2 years of service. And if the employer has made an alternative employment offer to you and you have declined it for some invalid reason, you do not receive redundancy payment. You have no right to redundancy payment. If you have performed misconduct of any sort, you have no right to redundancy payment. Well, the employee's remuneration may depend on provision of work. When an employee is laid off or kept short on time, then again they can claim for redundancy. However, if you want the claim, you should go for the claim within 6 months. The time is 3 months for unfair dismissal. Well, here it is for 6 months. Go to the employment tribunal before 6 months. And what you will get, if the claim is successful, what you will get the payment for redundancy. And what is the payment for redundancy? How is it calculated? Just like the basic award. Just like the basic award of, well, this is what you are going to get in case of a successful redundancy claim, which is a lower amount as compared to all these compensations. So have a look at the question. An employee can seek damages for wrongful dismissal in which of the following circumstances? When they are dismissed unfairly but with the correct notice period. When they are dismissed fairly with the correct notice periods. When they are summarily dismissed without justification. Well, the answer is C. Summarily. Summary dismissal comes under wrongful dismissal. Which two of the following are justifiable reasons for summary dismissal? When can an employer say that, yes, I have reduced the summary notice period, but I have a reason, I have logic? Misconduct, gross negligence, lateness, failure to follow a dress code. Failure to follow a dress code, not a reason. Lateness, not a reason. Misconduct and gross negligence. I've told you, we have read that under the justification for wrongful dismissal. Which of the following statements describe constructive dismissal? The employer dismissing the employee without the correct notice period and justification. Employer dismissing the employee without any notice. Employee resigns after they are required to work 40 hours per week when they are contracted to work for 30 hours. D. The employee resigns after they are not awarded a discretionary bonus. So whenever the employer changes the terms of the employment contract, whenever the employer breaches the employment contract and change any term of the employment contract without the consent of the employee, we say that employer has breached the contract, so employee can resign and go and ask for constructive dismissal. The answer is C. The answer to the question is C. Which of the following remedies are available to the employee in the event that they are wrongfully dismissed? What can they get? Damages, the money, re-engagement, alternative job, reinstatement, the same job back, statutory compensation. Well, they can get damages. Sorry, they can get the compensation, statutory compensation for the wrongful dismissal. All they can get is the money. Which two of the following are circumstances where an employee will not be entitled to claim a redundancy pay? When the employee would not be given redundancy pay. They could have been dismissed for misconduct before the redundancy notice period. Their claim is not made within 3 months of the notice period. Well, it is 6 months. So B is incorrect. They are involved in strike action after the redundancy notice is served. When redundancy has happened and then you go for the strike, you can claim redundancy. But before the redundancy, if you go for the strike, then you cannot claim the redundancy payment. They unreasonably refuse a renewal to their contract. Well, D is the answer. They have been provided with an alternative arrangement, an alternative job, an alternative contract, but they refuse them unreasonably. There's no solid grounds. So this is what redundancy is all about. So these are the certain areas of employment law where the examiner can definitely test you. And from here, we are going to move on to agency law. Agency and partnership. Partnership, agency, both of them, examiner would be asking questions on these areas. So we are done with English legal system, we are done with contract law, we are done with law of tort, and we are done with employment law. So the next in the series is agency. Agency arrangement. What is agency? A relationship which exists between two legal persons, principal and agent, in which the function of the agent is to form a contract between the principal and the third party. So, what is an agency according to the definition? Well, the relationship between principal and an agent. For example, if I had to sell some goods and I hire Mr. A and I ask him to bring me some customers, Mr. A go to the third parties and convinces them to come back and do a contract with the parent. So the principal and third parties are going to enter into a contract and A is going to get commission for his services. So the relationship, this relationship between principal and agent, where principal asks the agent to work for him and bring third parties to so that they can make up a contract, that is known as agency. That is known as agency. There are different examples of agency. Director is an agent of the company. Shareholder, director is an agent of the company. Partner is an agent of the partnership and the other partners. So there are different examples. Broker is an agent. So agreement could be express and implied. And there are certain types of agent. Partner is an agent, director is an agent, auctioneer, broker, promoter. We talk about promoter in the coming lectures, factors, commercial agents. So there are different types, different examples of agents. Well, how does the formation of agency occurs? Formation of agency. Agency could be formed through express agreement, where the principal is expressly going to appoint the agent, Mr. A, as his agent. It could be written, it could be oral. Express agency. Agency could be an implied agency. The principal has not appointed the agent expressly as his or her agent, but through implication, through some other position, they have become the agent. For example, if today you enter into a contract of directorship of a company, so you become the director today, and ultimately you become the partner, you become the agent of the company as well. Some of the other forms of agency are agency through necessity. This is obsolete these days, but agency through necessity is also possible. It occurs when you try to contact the principal and the person is not in reach, so you act reasonably, you act in a way which you think is quite reasonable to be acted upon, and ultimately you tell the person, you convince the person that I have acted out of necessity. I have become your agent. I did what I think you would do in such a situation. So that is agency through necessity. And we have agency through ratification as well. Ratification, where the principal does not know that agent is acting for him, but agent eventually brings up the third party to the principal. Principal can say no as well over here, but if the principal says yes, so that means principal has gone retrospective and ratified the act of the agent. Agency through ratification. But for that sake, principal should exist at that back date. This is a condition. So these are some other sorts of agencies, but the most important one is agency through estoppel. Estoppel we have read in promissory estoppel as well, where law is going to stop the person from taking back his or her promise. So estoppel here comes from, well, when there is a individual principal and there is no relationship with the agent. I have written down the name of the agent with dotted lines. You can see there is no express agency, there is no implied agency. However, the principal kept on saying to the third parties that Mr. A is my agent. So if you're going to make that representation, if you're going to hold him out as your agent, well, in the eyes of law, Mr. A will become your agent. Ultimately, Mr. A will become your agent. This is agency through estoppel, apparent agency, agency through estoppel. So if you have made a representation to third parties that yes, Mr. A is my agent, and even if he's not your agent, he becomes your agent, law is going to stop you from going back on your representation because you have hold it out to everybody that yes, is my agent, so he or she becomes your agent. So these are the certain ways through which agency is formed, and once the agency is formed, certain authority is given to the individuals as well, to the agent as well. Well, one of the main authority is express authority, where the principal expressly says, well, I have given the agent an authority of, say, for example, 50,000. Express authority. So agent can go and sign a contract and get into a contract of worth 50,000 on behalf of the principal. Then there is implied authority, where the agent gets the authority what everybody in that position usually gets. Usual authority. If you've entered into a partnership and usually the partners have 50,000 authority, you will get 50,000 authority as well. Usual authority. And if you're going to act outside, even in express or implied, if you're going to act outside and you go and make some contracts of 60,000, the rest of 10,000 would be paid by the agent. The most important one is ostensible authority. Ostensible or apparent. What the third party thinks that the authority you have given to the agent. So in agency through estoppel, person is not your agent, but you're holding out to third party that yes, he's my agent. And if it comes to you, if he comes to you, you are supposed to think that I have come to you and I have given him the authority of 100,000 to perform the contract of 100,000. So ultimately, Mr. A is going to get the authority of 100,000, which has been given through them through agency of estoppel, and this is known as apparent authority. This is how the principal has holded out the agent in front of the third parties. The innocent third parties would think that the agent has 100,000. So law says, well, apparently the agent has this authority. So yes, he's your agent. Even if the agent says that I have an authority of 100,000 and principal knows and principal does not condemn and principal says doesn't say anything, that means principal want other people to feel that this person has 100,000 authority. That is apparent authority. It is not what is written in the books, it is more than that. So when apparent is more than that, that authority is enforceable. So these are the three very important authorities: express authority, implied authority, ostensible authority, apparent authority. So how does an agency arrangement terminates, is brought to an end? Well, when the principal or agent dies, when principal, it could be when the principal or agent dies, or when principal or agent becomes insane, unsound mind, or if the agency is of certain time, so time expires, agency expires. Ratification, estoppel, by agreement, agency of necessity. Which of the following events does not necessarily terminate agency? Death of the principal, death of the agent, bankruptcy of the agent. Bankruptcy of the agent does not necessarily terminate the arrangement. One second, will the slide here. Which of the following statements regarding ratification of contracts by the principal is not correct? Principal must tell the third party the agent is acting for him. The principal must ratify the contract within a reasonable time. The principal must have the capacity to the contract. Reasonable time is correct. You have to ratify it within reasonable time and you need to have capacity as well. So A is wrong. Express authority, implied or usual or ostensible authority. Express and implied are collectively known as actual authority, and ostensible is known as apparent authority. So when does apparent authority arises? When the agent implies that he has authority, when the principal and third party make a contract, when the principal represents to a third party that the agent has authority. C. One could be, A could be correct as well. It would be when the agent implies that he has authority and principal It does not negate that thing. If this was the full line, that could be the answer as well, but C is the answer right now. What is ostensible authority? Well, apparent. Principal, agent. So, privity of contract says agent has no liability because agent is a third party. But you remember in the exception of privity says in agency, sometimes agent also has authority. Well, when the agent intend to take personal liability themselves, when it is a custom of that area, the agent should take the liability. When the agent is acting on his own behalf, there is no principle. So unless circumstances indicate otherwise, which party is not liable under a contract properly formed under an agency arrangement? Principal and third party are always liable. Agent is liable at times. A, because it is a third party. Which type of agent authority is derived from what is usual or customary? Implied. Wherever they say usual, customary, well, they mean implied. Which of the following is included in an agent's ostensible authority? The authority that the third party expects of the agent, the authority that the agent states that they have, the authority that is usual in these circumstances, well, that is implied, the authority that the principal expressly gives. So D is express and C is implied. So what is ostensible? What the third party expects the agent to have. And that must have been through the ostensible agency. In an emergency situation, a person may need to take control of another person's goods and deals. What do we call this? We call it agency by necessity. What do we call it? We call it agency by necessity. In which two of the following situations will an agent be liable on a contract? Where it is usual business practice for the agent to be liable, where the agent acts on their own behalf, where the principal intends the agent to take the liability, no. Where the third party agrees with the principal that agent will be liable, no. A and B. A and B. These are the two situations. So the examiner would basically merge this concept of agency with partnership. Partnership. There are three types of partnerships formed in the different Partnership Act. Partnership Act of 1890, that is traditional partnership, that all the partnership that we know about 1890, where all the partners have unlimited liability. Unlimited liability. Then there was a partnership that came under 1907. The name of the partnership was Limited Partnership. What sort of partnership is that? In the limited partnership, there is one partner with complete unlimited liability. That partner is known as general partner. He has more liability, so he has more rights. He has more extended rights in decision making. He's a general partner. The rest of all partners have limited liability. So this was under the Act 1907. Then the recent Act 2000 brought a concept of another sort of partnership, and that is limited liability partnership, where all the members, all partners have limited liability just like a company. So we'll be talking about these partnerships in our tomorrow's session, and we have discussed most of the topics over here. If you have any questions, you can ask. Handouts will be provided to you. For any queries, you can reach out at the email address that has been provided. And sorry, I couldn't get your question before. Siana Fasha, could you please explain previous question 1037? If you could just tell me which question it is, which slide it is. So if you have any other question, you can post it. It is on slide number 48. 48. Which of the following is included in an agent's ostensible authority? The authority that the third party expects the agents to have, the authority that the agent states that they have, the authority that is usual in circumstances. Well, this is implied authority, usual or customary or circumstances. And D is express authority. It is either A or B. So whenever a third party, in front of third party, a principal holds out an agent and tells that I have granted this agent this authority, so then third party expects the authority agent to have, that is ostensible authority. And question number 2, in an emergency situation, a person may need to take control of another person's goods and deal with them appropriately. This is how agency of necessity is formed, agency by necessity. Agency of necessity. So I have explained the first question. The representation should be made by the principal or anybody from the principal side. Yes, the agent can also tell them that I have the authority, but principal should know. And there must be evidence that principal does not stop the agent from saying this. So in this particular question, it is not mentioned. So if it is not mentioned, so we are going to assume that it is what the third party expects out of the agent. So that was your session for today, and handouts for all the session today, yesterday's and today's, both of the day sessions are provided in the handout section. You can get it from there, and if there's any query, you can ask it. And tomorrow we'll be talking about some different areas of the syllabus, and we'll be looking at how the examiner will be testing those areas. So thank you so much for joining in. Do chip in tomorrow as well. Thank you. Allah Hafiz.